Thank you again, everyone, for attending our third in the Brexit series. We promised to bring out-of-country settlement applications by popular demand. So Sarah and I, who are joint head at the Goldsmith Immigration and Public Law team in Goldsmith Chambers, are back here, and we're joined by Luke Piper, who we're grateful to, head of policy at 3 Million again. At 3 Million, and he's back again with us. So just by way of housekeeping before we do start, this recording is going to be available together with our slides so a few days after this webinar. If you have any questions, pop them in the chat box, but please put the name of the person who you have the question for. So it's not the chat box, it's the Q&A box. And just one other thing to flag, we have flagged up the donation page for 3 Million and the work that they do. So we hope that you can make a small contribution towards their campaigns and their work that they do, which is really important in this area in relation to the EU settlement scheme and Brexit, the work that comes from it. So we want to just look at the EU settlement scheme in relation to out-of-country applications, and I'll be dealing with that and Appendix EU FP, which is similar to Appendix EU, but just taking you through a few of the differences. Also, then Sarah will take you through the discretion within the EU settlement scheme and the post-grace period. That is in relation to any difficulties you might have had making applications and what those difficulties are and what might be accepted in relation to any difficulties you've had making applications. And then slightly different, but still important, taking us away from the settlement scheme, but important to EU nationals, is the issue of disclosure and the immigration exemption from the Data Protection Bill in relation to subject access requirements for EU nationals. And Luke's going to take you through that and highlight various aspects. And of course, the website for 3 Million also details a lot of the issues that are arising in relation to that. So just to take you through the deadlines, we all know that we exited the EU on the 31st of January 2020, and the withdrawal agreement came into force as of the 1st of February 2020. And we saw a period of transition implementation where individuals were allowed to enter the United Kingdom and continue to exercise their EU rights until the 31st of December 2020. And it left anyone who was in the United Kingdom generally by that date to make an application by the 30th of June 2021, with some exceptions. And this has come to be known the period between the 31st of December 2020 and the 30th of June 2021 as the grace period, which we will take you through in relation to some aspects of the settlement scheme when we're looking at that. You'll all be very familiar, no doubt, with the process of making an application in country under Appendix EU of the immigration rules. That's now what governs the settlement scheme and regularization of EU nationals. You also have, for out-of-country applications, Appendix EU family permit. So Appendix EU FP, essentially, and this is with reference to anyone who's out of country. We have flagged up, all of these are interactive links as usual, and they will ensure that you can go to the relevant parts if you are using this to refer back to. But we've also flagged up here the settlement scheme caseworker guidance, which is really important when you're looking at making applications, if you get stuck with reference to certain definitions or categories that you might be considering. Now, what I just want to flag up for you is the withdrawal agreement. It governs the continuing rights of family members and or of course qualifying British nationals. And this is where the settlement scheme rules are essentially drawn from. You have two further agreements. Those two agreements are with reference to the Swiss Citizens Agreement and the EA-EFT separation agreement, which deals with nationals of Iceland, and I think it's Liechtenstein, if I'm saying it correctly. So just look out for those agreements if you have nationals from those countries, but essentially for all other EU nationals, the withdrawal agreement is where we would go to, and what the Appendix EU and Appendix EU FP is meant to be reflecting. So the two acts there we've flagged for you. You have that the Withdrawal Act 2020 repeals the retained EU law relating to free movement and explicitly revokes the EA regulations. So you look at Schedule 1 with reference to that. But whilst it does revoke the regulations, there are, and we've already highlighted some saving provisions with reference to that regulations during this grace period and perhaps beyond, but we'll just be dealing with the grace period up to the 30th of June 2021. The withdrawal agreement is important because you'll see here I flagged Article 9. It contains the relevant definitions, including family members and so on, which is reflected back into Annex 1. And then you have Article 10, which sets out the remit, which is who is in scope. Again, that comes within the definitions of Annex 1. Article 18 will deal with who, or covers the issuing of the actual residence documents, and Article 19 covers the same, but only during the transition period, which is again up until the 30th of June 2021. Now, sorry, this slide is slightly dense, but we're just going to be looking at applying from outside the UK in particular, looking at Appendix EU FP and the specific guidance with reference to Appendix EU FP. That's the EU settlement scheme, family permit and travel permit guidance. There are still some provisions in relation to the EA regulations which have been retained, and that's what I was referring to previously. And you will have to look at the grace period regulations, which again we flagged there when you're looking back at individuals who might be covered by or with reference to the regulations themselves. We've had ongoing discussions about it. It's minefield, so basically you're going to have to dive into the grace period regulations, and we certainly had some discussions about the various categories and whether they do fall within those who can make applications from outside the United Kingdom under the EA regulations 2016. So look out for those individuals. I think it's going to be very short-lived because by 30th of June 2016, certainly that will have come to an end. Now, I just want to flag the difference between a family permit and an EUS travel permit. We all know what an EEA family permit, that's something issued under the regulations, but an EUS family permit is entry clearance, and it facilitates travel to an entry into the United Kingdom of an eligible family member of a relevant EEA citizen or of a qualifying British citizen. The one which is not so common but is important for us to know is the EUSS travel permit. Now that is something which provides a non-EEA citizen who holds valid leave under the EU settlement scheme and who has reported to the Home Office that their biometric card has been lost or stolen whilst they're outside the United Kingdom, will provide them with entry clearance to re-enter as long as they have a valid passport. So it's important to know that, because there have been several instances where we've heard individuals have travelled outside of the United Kingdom and they're left without any relevant document through which they can then re-enter the United Kingdom. So this is the route through which they would do that. Now, we have just flagged here, Appendix EU and the definitions under Annex 1, it largely does mirror Appendix EU categories and Annex 1 there. And we've considered this in quite a lot of detail in various other earlier webinars, which you can refer back to in relation, and they're all found on our website, and certainly we've tweeted them out on LinkedIn and so on. So they're there if you want to have a look at those. The slides are also available, and you can explore that in your own time. But looking at a family permit and also the travel permit, it's important to keep in mind what the validity of that document is going to be, because you might think that you can come to the United Kingdom and it's a valid document, you've entered the United Kingdom and you're going to be fine, but there's a relevant period for which it's going to be valid. And that is generally, for an EUSS family permit, it's going to be valid for 6 months from the date of the application. But if an applicant indicates in their application form that they intended to arrive in the United Kingdom after the 1st of April 2021, and that's a date to keep in mind, then and their date of arrival in the UK is more than 3 months from the date of decision, then their document's going to be valid for a period of 4 months from the date of their intended date of arrival in the United Kingdom. And that's found within the withdrawal agreement under Article 18(1)(b). So that's, again, why we keep referring back to the withdrawal agreement, and it's important for you to know that. And you'll see why when Sarah comes to talking about difficulties from outside when you're outside the United Kingdom that people might have faced and that we've heard about so far. Now, in relation to this family permit, it acts as a visit visa, but actually it's more flexible in that and anyone who holds such a document is going to be able to enter the United Kingdom as many times as they want to, travelling back and forth, as long as it's within that period within which it's been issued for. Just also to flag up, I think, the travel permit, it's just important to know that is going to be valid for a period of 6 months from the date of decision. And again, you can use that as many times as you want to travel. What do you do once you've arrived in the United Kingdom then? If you do have your family permit, well, and you want to stay beyond the period of your family permit, you have to apply, and certainly before the 30th of June, unless you're an individual who's arriving after the 1st of April, then, as I've said, you've got those 3 months to arrive, but you must apply. So you've got to take positive steps to make an application under the settlement scheme to apply for pre-settled or settled status. I say settled status because it may well be that you've had a historic 5-year period of residence in the United Kingdom. So that's something that you can consider, or you can ask to be considered in relation to whether you actually do qualify for under the settlement scheme. So just keep that in mind. And an alternative, a question that's been asked quite a lot in relation to what can we do if we arrive after the 31st of December 2020 and we're an EU national. Well, recently, as of the, I think it's the 31st of December 2020, the definition in GEN 1.3D, as I flagged up there, includes those joining individuals in the UK with limited leave under Appendix EU, mean EA nationals in the UK who hold valid limited leave to enter or remain granted under EU3 of Appendix EU. So generally that is, they've got a route, an alternative route under Appendix FM, and that's, you've got to ensure that you satisfy all other requirements with reference to Appendix FM as well. And you might think, why are we again flagging up durable partners? We flag this up because we've talked about it, I think, in nearly every webinar that we've done, which concerns Brexit and the EU settlement schemes, because it's a slightly tricky category. We've had so many queries about family members, particularly durable partners, and that's because they are being treated as a slightly different category, and I suspect that's to do with the litigation that we've seen in relation to Banjo, the recognition of durable partners in the British citizen context. But they are individuals who can continue to apply for EEA family permits until the 30th of June 2021. Other extended family members are going to be excluded, so anyone else who would fall under the Regulation 8 definition will simply be excluded, but durable partners are going to continue to be allowed. But there are certain restrictions or certain conditions attached to that, and that is that the partnership has to have existed before the 31st of December 2020. As long as it exists, and the EU national or the EEA national partner was exercising free movement rights in the UK before the 31st of December 2020, then they're going to be entitled to apply. We've often been asked a question about third country partners who were in the United Kingdom but didn't hold a relevant document, and they were not here on any other lawful leave. Well, if they think they would have to demonstrate essentially that they'd had lawful leave in the United Kingdom if they were to return back to apply as a durable partner to re-enter the country. They would have to demonstrate that they had lawful leave whilst they were here, either in the EU settlement scheme or in another category. They couldn't have been here unlawfully unless they returned back and there was a period of time which broke the residence, the time that they'd spent in the United Kingdom. I hope I haven't complicated matters slightly, but just to flag up that there are some restrictions. If they were here in the United Kingdom and they are thinking of going back to apply, they have to be aware that there are certain restrictions that will apply or will be attached to their application. So those are things to look out for. And with that, I'm going to hand over to Sarah, who will take you through the next part of the webinar. So thank you, Sarah.
Thank you, Samina. Yeah, Samina saying that's a slightly tricky category in the context of durable partners is quite the understatement. So absolutely, it's a real headache. And if anybody has tricky cases or wants to seek advice in advance of deciding what course to advise on when it concerns durable partners, then we would strongly urge that, because it's certainly complex. But yeah, we move away from that now, and we're just going to spend a bit of time with my slides, or the slides that I'm speaking to, on the various discretions that have been set out by the Home Office so far. The first slide that you see here on this area is very much COVID related. So I'm not going to speak to it very much, because we have covered that in a bit more detail, I think, in the second Brexit themed webinar that we did, so the one we did mid-February or so. But we thought it'd be useful to flag this up again, because again, obviously, a lot of cases are impacted due to the pandemic. So the first bullet point on this slide is covering any difficulties that persons have experienced in terms of evidencing their ID, submitting a valid ID document because of COVID. So your passport has expired, your ID card has expired, you haven't been able to renew that due to the embassy being closed or whatever, or the procedures changing. So there's some guidance there specifically in terms of automatic extensions of passports by country, so it's quite useful to check there. You have the guidance hyperlinked there on the third sub-bullet point. And then the second part of the slide is just to cover absences from the UK. So again, that's a bit of a minefield in itself, but the guidance is there. It isn't exhaustive guidance. It is by no means sort of outlined in detail as to how those discretions are to be exercised. What there is in effect summarized here. So effectively, the one major issue is the first sentence, that more than one absence of over 6 months and an absence of more than 12 months. So those two timescales there, obviously just one happening is enough, would break the continuity of the residence, even if the pandemic, however that is impacted on that person, has caused those absences. So if they're too long, more than one absence over 6 months, or more, just one that's over 12 months is enough to break the continuity. You then have the guidance on the single absence. One single absence of more than 6 months would be okay if there's an important reason for that absence, but again, it can't stretch over to 12 months. So you've got that sort of stopgap there. And the type of examples that are given in the guidance are here: that you're ill with coronavirus yourself, that you're sharing a house, and so forth, self-isolating. So that's just a snapshot of that guidance, and you have the guidance at the bottom again, specifically for COVID, and operational instructions to check as well. So do check that, but as I said, that's limited to COVID and how that has affected on the EUSS. So in the next slide, we're just moving out of COVID and looking at the general discretion that has so far been published, so to speak, so that the guidance is quite bare. But what we do have is here. So we all know we're obviously not very far at all from the deadline of the 30th of June, so just over 3 months away. The withdrawal agreement, again, another example as to how important it is to be conversant with the withdrawal agreement. That, if you remember in the second webinar that we did in terms of appeal rights, if something is not in keeping with how the withdrawal agreement was reached or is stated, that is a ground of appeal that you can try and pursue an appeal on. So really important to be conversant with the withdrawal agreement. And it's here that we have the express not permission, but an allowance for applications to be made under both Appendix EU and Appendix EU FP after the deadline, which is currently set at 6 months after the end of the transition period, which, as we know, takes us to the 30th of June. 18C, I've just cited there because that is one of the bases for it, but it's not really relevant to, I think, we think the practitioners in our world, in our community, and it's really 18D of the WA of the withdrawal agreement that provides probably the meat on the bones that we may need to use. And that is that the competent authorities shall assess all the circumstances and reasons for not respecting the deadline, and shall allow those persons to submit an application within a reasonable further period of time if there are reasonable grounds for the failure to respect the deadline. So I've highlighted there, underlined the reasonable grounds for the failure to respect the deadline. But of course, potentially there's two tests, two elements, two limbs to the test that need to be met, because it's also the act of submitting an application within let's go back to the slide just a minute. It's also the act of submitting the application within a reasonable further period of time. So it's not just you've got the reasonable grounds, but then you can't dilly-dally, and you've got to apply within that reasonable further period of time. So that's the wording in the withdrawal agreement. And then you've got at the last bullet point the guidance where that is followed through. And we can now go to the next slide to see what's stated there. And it's pages 24 to 25. As Samina said, it's all hyperlinked, so you can go straight to it, into those pages. And effectively, again, this is paraphrased from the guidance, so that's all there is for the moment. Examples of such reasonable grounds will include children whose parent, guardian, and local authority fails to apply on their behalf. I'm going to come back to that in a minute. People in abusive or controlling relationships who are prevented from applying. So that's an important safeguard there. And those who lack the physical or mental capacity to apply. Again, not exhaustive, but 3 quite large groups potentially of persons who may be affected. And then further non-exhaustive guidance will be published on what constitutes such reasonable grounds. So that it's obviously further guidance to come, so we await that. And then secondly, what I would wish to stress here is, again, a reiteration of what we have heard before, not necessarily seen in practice, perhaps, I don't know, but to underpin a flexible and pragmatic approach to considering late applications under the EU settlement scheme in light of the circumstances of each case. So I think that's important in terms of the flexible and pragmatic approach, and the more we remember that, it may be necessary to quote that back if you are making such a late application and you are needing support for the reasonable grounds. And lastly, further guidance would also be published on the process by which a person may, based on such reasonable grounds, seek a reasonable further period in which to make a late application. So that's that second limb in terms of, you know, when is that reasonable further period? Are there going to be any limitations? Are there going to be any stopgaps placed? And we don't know yet. So again, watch this space on the guidance. Before I come to the next slide, sorry, what I wanted to come back to is the children whose parents, guardian or local authority fails to apply on their behalf. So very coincidentally perhaps, but certainly timely reminder this morning. It was on the news. I don't know if many of you heard this, but it made the news this morning on Radio 4 with the Children's Society report. Reporting on what the Society fears to be a fairly low number of children in local authority care who are EEA nationals being supported to make that application to date. In the report, and I will put that in the chat box in a minute, in the report they estimate that there's only 39% of that group of children in local authority care who have made an application to date. Again, the response to that report by, I think, the Association of Local Authorities, I think, I'll put the link in the chat box as well, responds acknowledging, I think, the way I read it, that there has been some difficulties in ensuring a higher number, but also citing COVID impact on those cases and the strains that has put local authorities under. So just flagging that for now, but that's again for those solicitors and practitioners that may have family departments that deal with care proceedings and so on. That may be something to bear in mind. And just the last aspect in terms of the general discretion to cover here is just to flag that JCWI took a judicial review on the issue of the deadline, but specifically on what it argued to be government failures to ensure that there were safeguards for those more vulnerable groups, those more vulnerable communities, and making sure that they are not left slipping through the net when the deadline comes and passes. So I just highlighted that case there. It was a permission hearing that was heard on the 11th of March. You have in the sub-bullet points after the first main bullet point, the grounds that were argued by JCWI, but the High Court did not grant permission. As I mentioned, it was a permission hearing, so we haven't seen a judgment. I don't think a judgment would have necessarily been published on permission, but as it was reported in the media, the nature of any application scheme needing a deadline was an important feature for the judge in refusing permission, and also noting the Home Office's argument that there would be a further grace period, that there is this discretion to allow reasonable grounds when making a late application. So that are two things that featured when refusing permission. And the Home Office spokesperson, as cited in the news report, again, stating that the scheme is simple and straightforward. So I'm going to leave that there because I think we've all got our views on that. But again, that may be something to cite back. So that's it on the discretions, and we just leave you with some statistics. Again, just to reiterate that there are difficulties with persons knowing still about the scheme, needing to apply, knowing that they should apply, and so forth. Total number of concluded applications as of 28th of February this year, which I think is the latest period that is reported on the Gov website, is 4.81 million. But as the news reports again today show, that is recorded in a lot of the news reports as 4.81 million being granted or being decided. It's applications, and it will count repeated applications. So that figure doesn't translate into persons having their applications decided. It counts as applications when there may be repeated. And lastly, just to flag here, the second part of the statistics, the settled and pre-settled. So you see here the majority of applications are determined either by a grant of settlement or a grant of pre-settled status. There is obviously a small percentage of refuse, which does translate in a sizable number of refusals, but that will be statistics from the moment that the EUSS scheme opened, and when also the refusals were not necessarily attracting a statutory right of appeal. So we anticipate it's hard to see what that translates in persons needing advice and needing representations in their cases. But what we can anticipate is perhaps with the high grant of pre-settled status decisions, that there may be a fair number that need to be upgraded to settled status if they had claimed settled status initially. So look out for that as well. So that's just all I wanted to flag on the statistics. And then the next two slides are just there for your ease, really. Transitional arrangements. Don't go there unless you have to, but we suspect you will have to at some point. And hopefully this slide will make it easier with a little ER, because it's really not very easy. But you have it all there. And then the sources of information, again, as an ease, as a quick guide, if you do need to access all of these primary resources. So on that note, I'm going to hand over to Luke, who's now going to take us through the immigration exemption on data, the disclosure, and Samina is just in the process of sharing Luke's slides.
And while she's doing that, that was really helpful overview, particularly around this issue of absences. And I think what's now emerging is that where people are advising clients about thinking their future absences and how they calculate them, is that there is this tension around what is the calculation, how does it work? Is it a 6-month rolling calculation, as the government is saying? The European Commission has said in their papers that they've published that it's 12-month consecutive. So there's a conflict and difference in interpretation there in terms of your calculating the absence. But what's quite troubling, though, is that the approach that's taken by the UK government is really rigid. So if you are absent for a period of up to 12 months, and you're wanting to rely on that, you can only rely on one period that's beyond the 6 months and less than 12 in that 5-year period. So if you used it, and say, for example, you leave and you come back on, I don't know, say 7 months into this period, and you come back for a day, that's it. You won't be able to use your special reason ever again, and it feeds into then the calculation. So there's a lot of variables and problems that are on the horizon. So I would very much take what the government is saying with a pinch of salt, but it's really hard to plan and manage people's absences, particularly because of COVID. In terms of that moving forward to acquiring permanent residence. And we know that there is already some litigation potentially in the wings on this particular issue, and asking the question, really revisiting two quite important questions in this question around absences. The first being, what do we mean by residence? Does it mean physically present in the country, or does it mean living? What does it actually mean? And there's some historic European Court of Justice cases where they have taken a very liberal approach to the notion of residence that steps beyond just physical presence in a place. And secondly, visiting the question around proportionality and how that feeds into an assessment of absence. And so again, there's a real question as to whether or not there should be a proportionality element to establishing whether or not somebody has broken their continuity of residence in the pursuit of acquiring a permanent right. So I know that there's some work that's going on around the fact that a single prison sentence can break your continuity of residence, which is essentially suitability by the back door. And that is really controversial because you are essentially losing your right to permanent residence because you're serving a prison sentence that otherwise wouldn't cause you to be expelled. So it's a very touchy issue, both at a UK domestic level, but also at the other parties to the agreement, so the member states of the European Union. So there's a lot to unpack there actually in the absence debate. And so I would say watch this space, but when you're advising clients, as you guys have been saying, so got to be really, really careful, because at the moment, the government is being nice and light touch. That's not to say that that is going to always be the case. They've been quite happy to do the sausage factory of getting everybody through the machine and getting them the status. But as the pool narrows and the number of applications are smaller, the analysis is likely to be more intense. And as we've seen, as is the Home Office's way of doing things, when things become a legacy, which ultimately the settlement scheme will do, they become tougher. So these are the sorts of things that practitioners need to be thinking about now very carefully and seeking advice early on and mapping this out properly. I know it seems completely mad, but particularly in absence, it's really, really important. And then finally, just before we go on to this topic, which is also really important, and I promise you I can make data sexy. I can and I will. The one thing I wanted to say was just talking about the backlog of cases. So we know that there are a lot of cases that are in the backlog, but the question as to how many and how long for has been a bit of a mystery. And we were able to get some insight with some data which suggested that the case numbers of those cases which are waiting longer than 6 months is around about 13,000 cases. Longer than 12 months is about 6,000. So that's a big drop in comparison to the figures that were out last year. But the numbers do seem to show that there is this narrowing of cases in terms of that have been aged, but there is this kind of backlog within a backlog that's aging and is staying stagnant. What those cases comprise of, who knows? But I think some practitioners probably can have a good guess of the types of cases that are locked in there, that are pending and then keeping it. It's worth keeping in mind that really anything that's delayed more than 6 months, you really need to be speaking to a barrister, I would say, and looking into what options there are in terms of pursuing a remedy, because it's unacceptable to keep somebody waiting that length of time. Anyway, to the exemption. So if we can go to the next slide, please. So the immigration exemption is a tool by which the UK, indeed any data controller, can deny somebody access to their data. It's been going along for a long time now, since 2018, and I'll unpack a little bit about its history in the next slide. But why is it so important now? Well, as I'm sure all of you know, yes, we've exited, and yes, we have a withdrawal agreement with the EU, and yes, we have a free trade agreement, but the terms of that free trade agreement are yet to be finalised and concluded, signed and sealed. And one of the key elements of that is the UK's pursuit of adequacy status, which essentially means that the UK is recognised as being suitably capable of managing people's data. The exemption, we are saying, is actually showing that the UK can't be trusted, because it has this very onerous term. And we're currently doing some work with the EU institutions to persuade them that this is a barrier to adequacy and that the UK should really revisit the exemption. And we need help from practitioners to make the case, and I'll explain why it's so important and what you can do to help us. So the next slide, please. So the immigration exemption is a clause that was born from the Data Protection Act 2018. Now, for all of those of you who remember it well, and probably it's from all the trauma of having to think about GDPR in the context of working in a law firm, but it incorporated an immigration control within there, which essentially restricts people's access to their personal data, where it prejudices effective immigration control. And this includes rights to personal data. It includes rights to understanding where data is being shared. Now, any of you who have any history of dealing with the Home Office, particularly in complex appeals, where you're trying to establish history and a detailed chronology of a person's case, you're doing a subject access request. And if you're wanting to understand the person's background, or indeed what's going on in their case, both from the perspective of a device or even from an unlawful detention claim or such, these are really vital. And the immigration exemption is quite broad in that it says that they can deny a person access to their data if it's in the interest of maintaining effective immigration control. So we'll go to the next slide, please. So there's no definition of what it means. And during the bill, when the Act was a bill, the analysis of this was gone into by Parliament, but the best that we got was that it's a wraparound turn to try and cover everything. So the government even admitted that it's quite a broad test, but there's no clear way to understanding how this test is applied in a proportionate way. There's no guidance. There's no real clear structural framework in terms of how the exemption can be applied. It's important to say it's not just the Home Office who can apply the exemption, it is all data controllers. So that is landlords, employers, Serco, the whole lot, soft posterior, all of them. They have the power to apply this restriction. The restrictions are, in practice, far-reaching, including capturing the rights the government have said are not covered by the exemption. It's quite broad. So we, so go to the next slide, please. So we issued a judicial review back in 2018 of this exemption. The judicial review is ongoing. We currently had a case in the Court of Appeal a few weeks ago. We're pending a decision on that. But it's a really fundamental part of the government's ecosystem on immigration control. Data and management is now central to immigration control. Indeed, data and management is central to government functioning, full stop. Now, since we've issued these proceedings, we've been able to establish that the exemption, and this was back in 2019, I think we got this data, that the exemption had been applied 60% of all subject access requests made to the Home Office. And up until the court case, the government were not informing individuals that the exemption was being applied. Indeed, in the case that we had in the Court of Appeal, we wanted to get some insight into terms of how they were telling people. Was it in a letter? What did it look like? And they say that they send letters telling people when the exemption is adopted. Now, the ICO, which is the Information Commissioner's Office, has only received 3 complaints, and that was as of May 2020 of its use, despite the very high number that it's been adopted. And we've had a recent FOI which showed that between January, in the whole of 2020, bar December, the exemption was used 72.6% of the times, and the Home Office had no information in terms of any challenges or any appeals around that. And this is just in the Home Office in terms of subject access requests, which I think we can probably imagine most practitioners are using it in that instance. But it's unclear to us in terms of what is happening outside the Home Office in other government departments, or indeed with contractors and local authorities. So go to the next slide, please. So what should people be looking for? Well, as I say, we understand that letters now have been sent where the exemption is applied. What data is being redacted, and is it clear? Is it why it's being redacted? And we're really keen to get information from practitioners and insiders who are dealing with this stuff, just to get an understanding as to what instances and what it looks like where they're using it from people's point of view. Why is this important? Well, it's fundamental really to, in terms of transparency and understanding of data flow between government departments and individuals. The landscape at present is still quite narrow in terms of where data is used and how it's used, but we are already seeing an emerging culture of data sharing practices between government departments. For example, the 3225 cases, where the HMRC and the DWP and the Home Office worked in partnership to identify information and data on people. There's clear evidence of mass data sharing between the Home Office and HMRC and DWP, so that they can identify people who are working illegally, to target them and close down businesses, etc. Now, that all seems quite rational from a point of view of immigration control, despite how nefarious that may seem in terms of people's rights and people's information. But the Home Office's data is not great. They are not good at being a data controller. Neither are other government departments. Indeed, most people aren't very good at being data controllers, including landlords and employers. It's not a thing that people find easy to do. And where people don't do it well, stuff goes wrong. And the risks that people are exposed to if bad information is shared is a real problem. But where we don't know and where we can't see and we're blinded from it is a real undermining of how justice is done and how government is held to account. That's why we're challenging the exemption. We're hoping we can get more headway with it. But this is very much a long-term project. We've been working on this since 2018. I can't believe it's been almost more than 3 years I've been dealing with this wretched thing. But it's a really important issue because it strikes to the very heart of migrants' rights and their access to their data and the information that the government holds. So if you do come across this, if it's something that you see, something that you've experienced, we at the 3 million would love to hear from you. So thank you very much. I hope that was helpful.
Thank you, Luke. That was really good. And yeah, and that it's when you are applying for disclosure, it's usually because there's a reason and that you need that evidence. So it's important to be aware of what you can do when that's being invoked. Samina, do we have any? I can't see the Q&A.
I'm just checking for Q&As. We don't have any open Q&As at the moment. So I think that brings us to the end of the third in our webinar, Brexit webinar series. Thank you all for staying with us, and thank you again to Luke for joining us the third time. And I'm sure we'll have one post 30th of June to 2021 to round up what's going on, and Luke, we'll hope to have you back here then as well with us.
Yeah, I think just to say that the reasonable grounds policy is due to appear apparently in the next few weeks.
Okay.
And I suspect that a lot of people will be scrutinizing that in quite a lot of detail. But you know, I would say to all the lawyers who are here on this, don't underestimate the scale of the problem. I think it's probably going to be a lot bigger than people probably realise, and it's not going to come with a bang. These things don't work like that. I think Windrush taught us all of that it doesn't just happen; it trickles. So I think it's really, really important that people keep an eye on this stuff, yeah. We'll definitely be in touch to talk more about it in due course, for sure.
Thank you. Yeah. I'm grateful for all the work that you do. So certainly, please, anyone who's attending our webinars, think about the donation towards the 3 million campaigning and the organisation. But thank you very much then. We'll end there. Bye.
Thank you.